Hello, this is a call with Andrew Morris and Eli Tamkin. Let's just make a quick introduction here, and then we'll get right on to our topic of mediation. I am someone who has been trained by the Ohio Supreme Court in mediation. I'm a real estate broker who concentrates primarily on short sales, and I represent people in other ways as well in real estate. I have sent a lot of business to Eli Tamkin because he makes a concentration on foreclosure defense. Many of my clients need this service. He has actually done some interesting things with mediation and had some experience in mediating foreclosure defense representation. And so, hi, Eli. How are you doing? You there?
Yeah, I'm here. This is Eli Tamkin. How you doing, Andy?
Is there anything I missed there? I know you do a lot of bankruptcies as far as part of your representation as well.
Right. You basically hit it. I concentrate my practice in bankruptcy law and foreclosure problems.
Okay.
I do have areas of law as well, but that's the main concentration.
The reason I have this call with you is you've told me some interesting stories about mediation, which we may get to here in this conversation, things that you've done. But first of all, let's just start. What is mediation?
Well, the purpose of mediation, as it relates to foreclosures, it's a cost-efficient way of resolving foreclosure disputes between the homeowner and the bank. Really, the purpose of mediation is to try to work out new mortgage terms if the homeowner wants to keep the home, or other issues, other ways if the homeowner wants to give the home back or liquidate the mortgage note.
Okay. So how did mediation get started in the state of Ohio? When did it get started?
Well,
is this briefly new?
It got started around 2008, really. The Ohio Revised Code, Section 232306, mandates that mediation be an option in foreclosure disputes. Really, as it relates to Cuyahoga, there was a program that was led by Judge Eileen T. Gallagher, and she basically got the court's foreclosure committee together, along with other legal and foreclosure prevention community organizations together to form this mediation program in Cuyahoga. So it was actually developed in collaboration with the legal community as well. It's a program that's directed by Andrea Kinnest, and it's on the 10th floor of the Justice Center. Not all judges in Cuyahoga participate in this program. Judge John Russo has opted out. I've done cases before him on foreclosure, and his court still encourages mediation if the homeowner wants to do it, except that it's not through the court's mediation department. Basically, the mediation is a useful device if the homeowner wants to keep his house or if the homeowner wants to give it back. And we can discuss the different ways this is applied in our discussion.
Should everyone in foreclosure do mediation, or, is it just for some
Well, mediation is a good device for somebody in foreclosure because it stops the foreclosure process.
Is mediation a non-judicial process, by the way? How is it different than, say, just letting a property foreclose, or like a standard judicial dispute where you have two parties, a plaintiff and the defendant? How is it different than that, or is it just part of the judicial process?
Well, it is. A person has to formally request mediation, and that's done with a form that's provided by the court. And generally, it's attached to the complaint, it's done in the courts.
Okay, so it is kind of a quasi-judicial process, I guess you could say.
Well, it is. It's done. It is a judicial process in that it's done. It stops the foreclosure process, and it's conducted by the court, by mediators who are hired by the county to conduct these hearings.
But my understanding, though, is that mediation is actually if an agreement is reached in mediation, it's not. It will be generally, accepted by the judge and made into a court ruling, but it's actually something that's mutually agreed upon, correct? Which is actually kind of ideal.
Well, although the Ohio Revised Code says that the court can order mediation, generally it's done at the initiative of the homeowner. The court can actually compel the parties to come to terms to resolve a mediation. That's really up to the parties to do that.
Sure. So it's up to the parties. What if we come to a mediation and we cannot come to agreement? See, I'm a homeowner in foreclosure, and I want X, and the lender is saying, forget you, Andy. That's totally unreasonable. We're not going to do it. Whatever. We're going to just walk away. What happens then? You said the judge can't compel anybody to come to mediation.
Well, let me say that I've done quite a number of mediations in Cuyahoga, and I can say that from my experience that the banks do try to be flexible when it comes to these. My experience is that it's much more difficult to negotiate a loan modification with the bank directly, and the mediation process facilitates this. And the banks generally tend to be more receptive to the needs of the homeowner, and they'll do what they can to assist the homeowner either to save the house or to give it back.
Yes, and I assume also that they could possibly even facilitate a short sale or any loan modification or any kind of loss mitigation option. Correct?
Well, actually, that's correct. If the homeowner wants to liquidate or give back the house, then by requesting mediation, so that will stop the foreclosure process, and then the homeowner can tell the bank, in the court, that they either want to do a deed in lieu or a short sale or some sort of consent entry, whereby the homeowner agrees to give back the house and not be liable for the deficiency of the house, but in that case, we'll go to a sheriff's sale. That's sometimes helpful if the homeowner doesn't qualify for a deed in lieu, but they can still come to an in-court agreement concerning giving back the house and being liable for this deficiency.
Interesting. And let me say this: in my training, I was really amazed with the power of mediation and some of the potential for it, because my understanding is a lot of these banks, they don't, and I know that practically it works out in different ways, but a lot of these banks, most of them are not based right here in Cuyahoga County, that are foreclosing. And although the judge cannot compel either party in mediation to have to a specific agreement in the mediation process, they can compel a party to come to mediation, which is, for some kind of homeowner who's been stonewalled with their lender, trying to get something done, and they get the call centers over and over and over again, and get closed doors for whatever they're asking for, whether it's a short sale or a loan mod. After being stonewalled, a mediation can be kind of a breath of fresh air, because the judge can compel an actual decision maker to sit down at the table face to face with you. And once that's actually happened, there's a lot of motivation. If you're sending an executive or vice president, you're flying them across the country, or even a phone meeting, if you're making this kind of investment, and the judge is compelling you to do so, there's a certain amount of, at that point, they're going to want to actually work something out and make that investment pay off for the lender, not just do nothing.
Well, actually, that's true. Really, although it's really the homeowner's decision to mediate, but once he agrees to mediate, the bank really can't opt out. Okay, they have to go. They have to do what they can to try to reach a solution. Now, from my experience, if the homeowner wants to keep the house and he can show that he can make the mortgage payments, he's employed, so the bank will try to work out some sort of modification. For example, the bank may agree to lower the interest rates. The bank may extend the terms of the note, or the bank will generally what's called capitalize all the arrearage, the amount that's overdue, and put it back into the note in order to lower the monthly payments. So the banks, as a general rule, will cooperate with the homeowner because it's done under the court's auspices.